Oftentimes in consultations, clients will ask me, well, should I do a quitclaim deed, a deed in lieu of foreclosure, or file a bankruptcy? And there's really pros and cons to each of those things, but a lot of times a bankruptcy at times will make more sense than doing just a quitclaim deed or deed in lieu of foreclosure. We're not going to talk as much about that within this video, but I want to focus more on timing of when a quitclaim deed or a deed in lieu of foreclosure may make sense if you're also filing a bankruptcy. So, if you have filed a bankruptcy, let's say a Chapter 13 bankruptcy, for example, and you are surrendering property within that Chapter 13 bankruptcy, and really it could be the same as if you're doing that in a Chapter 7 as well. If you're doing a Chapter 7 or a Chapter 13 bankruptcy and surrendering property, it may make sense after your bankruptcy is filed to file a quitclaim deed or a deed in lieu of foreclosure. Let me explain why. When you file a bankruptcy, it's going to wipe out your debts. But there's tucked away in the laws, it states that if you have a homeowners association and your house has not been foreclosed on yet, but you have surrendered your rights within a bankruptcy, that you would still technically be responsible for those homeowners association dues until your house is actually foreclosed on. Same goes with property taxes. Technically, you're still responsible for the county property taxes until your house has been foreclosed on. Well, after filing a bankruptcy, there's an automatic stay that goes into place that would prevent a mortgage company from foreclosing on your property, at least for some short duration period of time if you're surrendering that property. The problem is, though, there's so many houses that have been foreclosed on in today's economy that mortgage companies are slow, or there's so many houses that are behind in today's economy that mortgage companies are slow to foreclose. So it's not uncommon for there to be 6 months or a year that goes by after you've surrendered a property within a bankruptcy until they actually foreclose on that property. Well, if that's the case, those 6 months to a year, you're still responsible for the homeowners association dues for each and every month, as well as the property taxes for that year. If you do a quitclaim deed, Q-U-I-T, quitclaim deed, or a deed in lieu of foreclosure, then you're saying, I want to take my rights in this property and I'm handing those over to the mortgage company so they don't even have to go through the foreclosure process. Doing that ensures that you're not responsible for any future homeowners association dues and you're not responsible for the property taxes. So that's why a quitclaim deed or a deed in lieu of foreclosure may make sense for you if you have filed a bankruptcy. Oftentimes we'll encourage our clients to do those two things in tandem. File a bankruptcy, and then usually we encourage folks to do a quitclaim deed after filing the bankruptcy to the mortgage company. Again, that can be somewhat complicated and timing is important in this situation, so make sure you touch base with your bankruptcy attorney to find out exactly how they want you to go about it, but that's why you might want to do a quitclaim deed or deed in lieu of foreclosure after filing bankruptcy.